mental health. We're still that. When do we become a commission?
So this subcommittee is a subcommittee of the Joint Subcommittee to Study Mental Health Services in the Commonwealth in the 21st Century, also known as the Deeds Commission. The Behavioral Health Commission has been meeting this summer as well, but they continue to be distinct bodies until the end of this year.
Okay, so as the subcommittee of the Joint Committee, we are meeting today as directed by HB 2047 and Senate Bill 1315 to look particularly at the issue of whether or not make recommendations about the standard of danger to self or others that might be used following an acquittal based on that might have been influenced by the diminished capacity in the case before the court. Hopefully, I have stated that correctly. Do we take roll virtually and in person?
Madam Chair, Delegate Bell.
Here, present.
Delegate Price. Delegate Ranson. Delegate Watts.
Present. So is that a quorum? Or do we need to wait for action at the end?
Madam Chair, we need one more for a quorum.
Delegate Price will join us later by virtually. Do I understand?
I believe Delegate Price may be planning to attend. I'm not sure. She said she may be late if she is able to make it. If we do not have a quorum, what we can do is have a recommendation that isn't voted on that comes out of this subcommittee for the full.
Okay. Thank you so much. Yes, Delegate Bell and I have often outlasted many a delegate. So
We were going to anyway.
that's
We
right.
would wear them down.
All right. Now, Sarah, I can start with an overview, but I'm assuming that you're going to give a more definitive overview.
I can do that, yes.
Okay. Unfortunately, delayed by a major email server problem that I had in the last 48 hours. Only just recently did I, last night, send to Sarah, our esteemed counsel, the email traffic that had occurred as the House Court Subcommittee attempted to work prior to, in between formal meetings, on wording, particularly on, I shouldn't even say particularly, on SB 1315 as it came over to the House. While I tried to cull out some of that email traffic, not even with all attachments, I think it's probably an estimate of at least 50 pages of email traffic back and forth with a lot of very significant meat in it as far as mens rea and what other states have done on the standard, a lot of questions raised about what particularly centered on what happens to the individual if they are acquitted based on diminished capacity, and how that is approached appropriately, and whether or not in such an approach we needed to change the standard as far as immediate danger to self or others, given that the individual might have been, for example, on their meds, and who would make this judgment, how that judgment is best made. The bill that was passed clarified that the presiding judge, who would have knowledge of the history of the individual, was appropriately able to do so if he chose to do so. As I understand, the bill, however, does not require that, but just authorizes the judge to so do. But it would still be under, or at least there's certain significant question, that it would still be under what exists in 19.2 as far as immediate danger to self or others. So that these are some of those issues out there that were significantly discussed, but a lot of questions still remain as to how this is resolved, and therefore I take responsibility for the enactment clause that sent this to the Joint Commission. I feel, as I have tried to get back into all of that work that was done last February, that it really underscores for me how glad I am that the Joint Committee is now a standing commission and will have staff, because I do not see these issues, and I use the word plural, are appropriately resolved just by the Crime Commission, who wouldn't have the mental health issues, nor by the Health Commission, who wouldn't have the legal issues of a criminal trial, nor necessarily have the emphasis on mental health that the Deeds Commission has underscored the importance of that focus in the last 5-6 years. So with that overview, if I can now turn to council for a more studied overview of what we have before us today.
Yes, Madam Chair, and I've brought Taylor, who has worked on this in the court's crim sub, because criminal law is far outside of my normal subject matter area. So,
esteemed councils.
My esteemed counselors, yes,
Brewers.
can't do it without Taylor. So, as you stated, basically what we have is a pair of bills that were referred to the Joint Subcommittee and then referred by the Joint Subcommittee to this subcommittee. The bills are House Bill 2047 and Senate Bill 1315. And what they did, the way I think about it, there were sort of two pieces to these bills. The first piece was, as you said, we added a code section in 19.2, which is...
Madam Chair, may I ask, do you have a handout, or are we following along somewhere? Or?
I did not.
That's fine. That's okay.
Okay, sorry, did
That's
not
okay.
print the bill. So the first part adds a new code section in 19.2 that basically allows a defendant to, or it says that a defendant basically can introduce evidence of their mental state at the time an act for which they've been charged with a crime occurred. So what it would do is allow a defendant to introduce evidence that shows that they had a mental illness at that time, a developmental disability, an intellectual disability, or autism spectrum disorder, and that because of that condition, lacked the ability to form the specific required intent that is an element of the crime. Because they did not have the required intent, they cannot be found guilty of the crime. That's the context we started out in. Then, as I understand it, there was a great deal of discussion across several venues about what happens to that defendant when they are found not guilty and they are acquitted. So an amendment was added to this bill that authorized a court that is hearing a case in which this type of evidence is introduced to issue an emergency custody order pursuant to 37.2-808 if the court feels like the person meets the criteria. We then had an enactment clause added to the bill that directed the Joint Subcommittee to study mental health services in the 21st century to study the relevant standard of danger to self or others that may appropriately be applied to persons found not guilty because of the evidence that this act would allow them to introduce, what the right standard would be for the ECO that might be ordered. So the way this bill is drafted, it makes answering that question somewhat straightforward, which is this bill is set up to say that if the court determines that the person the acquittee, meets the criteria for the emergency custody order that we currently have in the code, the court's going to be able to issue that order. But the person still has to meet the existing ECO criteria at the time that the court makes that determination. As a refresher, the criteria is that at that time, the person has a mental illness, and there exists a substantial likelihood that as a result of that mental illness, the person will, in the near future, cause serious harm to himself or others, as evidenced by recent behavior causing, attempting, or threatening harm, or other relevant information, if any, or suffer serious harm due to his lack of capacity to protect himself. The person is in need of hospitalization or treatment, and the person is unwilling to volunteer or incapable of volunteering for hospitalization or treatment. The second paragraph of subsection A of 37.2.808, which is the section that lays out the ECO criteria, tells us, gives us a list of things that the magistrate or court might consider in making this determination. That includes things like recommendations by a treating or examining physician or psychologist who's licensed in the Commonwealth, any past actions of the person, any past mental health treatment, relevant hearsay evidence, any medical records, affidavits submitted by witnesses, and other relevant information. So it's a pretty broad net that they can cast there to look at to decide if the person meets the criteria, but they do need to meet the criteria at that time. My understanding is that, so I think when we look at the question that is posed in this enactment clause, the answer is fairly straightforward, which is, under the bill as it is currently drafted, the person can only be ECO'd if they meet the current criteria. One of the questions that has come up is whether we need to amend that criteria or change that criteria or do something else that would link that person to services. And I think involuntary services, this is services they'd be mandated to comply with. Your options really in this case are doing nothing to the criteria. You could look to make some sort of amendment to this criteria. I think in doing that, you're running into two possible problems. The first is that any amendment you make to this criteria is going to apply to any person who might be subject to an ECO. So that's a much broader category than who we're talking about with regard to this specific change in 19.2. It could also have a number of unintended consequences to our existing mental health system. You could look at whether it would be possible to create a different set of criteria for a person who is found not guilty because of the evidence they introduce under the new section in 19.2. Or we could look at whether the ECO is really truly the appropriate pathway here, or if there is some other pathway that might be more appropriate. And that could be anything from, this is where I'm going to get a little out of my lane in the criminal law, but I understand you could have a finding of guilty, but require some sort of services or something like that. In talking to some of you and reading through the background information we have, I think you may be best served in this situation by referring that matter, the question of, is the ECO the appropriate pathway? And if the ECO is not, what is the appropriate pathway? If it is the appropriate pathway, what changes might you want to make to the criteria? To the Behavioral Health Commission, because as you said, Madam Chair, they will have permanent full-time staff who will be equipped to do that sort of deep dive on the both qualitative and quantitative issues that we see here, really give you an independent look at what other states are doing, how they've handled this problem. Do they have do they use an ECO process or something different? And you can also specify a broad array of stakeholders that might need to participate in that process, everyone from law enforcement officers, the Supreme Court, Commonwealth attorneys, and also our mental health experts, our mental health advocates, and individuals who are on both sides of this issue.
Ms. May, is there anything you'd like to add to that?
Thank you, Madam Chair. Not at this time. I think Sarah covered kind of what the bill does and some potential options that could be considered or looked at. But unless there's questions, I don't think anything right now.
I want to start by clarifying or asking, and certainly I assume that the Joint Commission can phrase this as they want, should we make recommendations to the Joint Commission, that this study by the Joint Commission would not be limited just to the standard that might be used to determine danger to self or others, but that it would broadly look at the procedures and how such a determination might go forward, what the role would be of the presiding judge, of the who had just heard the case, all of the procedures that might even be as detailed as what we have for drug courts and how we approach the issues there. So with that clarification, I'm seeing nodding heads. So if we can make a recommendation that goes far beyond what the enactment clause stated, which was just the standard for danger to self or others.
Madam Chair, yes, we can. If this is the recommendation that did come out of this group, we could be as specific as possible, and I think that would actually be somewhat helpful to the Behavioral Health Commission and the Executive Director and staff as they get into this. And I think based on what I've heard about this issue in the last few weeks and over time is that would be the appropriate study to, instead of just focusing on that dangerousness criteria, include that as a piece, but take a broader view to say what is the appropriate way to accomplish the goal, which from what I understand was to say there may be people acquitted under this code section, the evidence allowed by this code section. that we may think needs some sort of services and how to make that connection.
The goal and slash the concern that I've heard from almost all interested parties has been, how does the person get services? If the person has ended up in a criminal proceeding, how do we make sure that this person is served so that this doesn't happen again just under criminal law, not to mention the mental health needs of the individual. Delegate Bell?
So I have pulled up some of the voluminous emails you and I had back, and I'm looking right at them. And it says the issue is what happens when someone is found not guilty by this new evidentiary rule. And I think I would suggest that what I suggested to you at the time, and I could almost read it, but that this is not a place where there's going to be a consensus, meaning 100% of the people find it agreeable. And that doesn't mean we can't act. This is a place where there will be compromises, not simply because the goals that you just stated are not shared by everybody who speaks before us, and the emphasis within those goals, I think, also is not shared by all. And as you know, I ultimately voted against the bill because of these concerns. I would suggest that if we're going to have the committee study it, commission rather, we commission or committee at this point? I guess that's the issue.
We, as I understand it, we as a subcommittee of the Joint Committee
Right.
are going to make a recommendations that the Behavioral Health Commission study
Got it.
it.
Okay, I'm going to just blur the other commission. Okay, would ask that I think that the issue is what do we do when someone is acquitted? And what I mean by that is you can describe them in the nature of services, you can describe them in the nature of what happens to the person, you can describe it in how do we ensure that it not happen again from their perspective or from the public's perspective, but I think that that's what we're getting at. Now, I have spoken probably after you to as many people about this, significantly less than you, but more than everyone else, and conclude that, again, there's not, if we had a big crowd here, some percentage would say leave it exactly alone, we have it exactly right. Some would say every single thing you did was wrong. Some would be somewhere in the middle. But I do think this is, I'll say what you and I talked about back in February, that this is a place where ultimately policymakers are going to have to plant a flag and understand that it won't be something that 100% of the people are going to be supportive of. They may accept it, but they may not be supportive of it. And I think that that's going into it with that understanding will probably help us get to a reasonable place to get to that.
But that also, it won't satisfy everybody, and I'm going to add to that, therefore it'll be a work in progress.
Right.
But that it's important that we clarify, look at some of these things that have been raised by this bill that is statute, but which has a significant questions, and I know the Secretary of the Supreme Court has raised questions. I've had conversations with Commonwealth's attorneys who are not aware that the presiding judge could carry out a ECO. There's just an awful lot there that needs to be looked at with the kind of serious legal counsel, all stakeholders, mental health stakeholders and legal stakeholders really at the table. And I'm going, while I'm speaking, I'm also going to say, Delegate Bell, Rob, from my point of view, my concern about this goes all the way back to the work that you headed following the Virginia Tech massacre, where my awareness of Virginia's standard being immediate danger to self or others was something that I did not have a comfort level based on my mental health involvement before then with a number of family members in particular who had decades of relationships that they were concerned were not being fully considered under the standard of immediate danger to self or others. And this gives us a possible opportunity to narrowly perhaps apply a different standard, but all of that needs to be considered as to what would be considered if you had a different standard or an expanded standard and how, et cetera.
Madam Chair, I would think, I'm sorry, may I ask a
Yes,
question?
please.
So I think this is included in the way you've described it, but I would hope we would also review what happened in other states or, I'm
Yes,
sorry,
absolutely.
what is done in other states, and I say that because as this sort of rolled along, it went from sort of what other states are doing to an outlier, a significant outlier, and I think that it is often helpful and informative to us to look at how other states, this is not a unique to Virginia problem. You have people that ultimately are not intended for the criminal system, but what do we do at the conclusion of the time when that decision is made, what happens next? I think other states have a variety of different approaches, and I know that you sort of have, I think you sent them to me, but charts and spreadsheets and all the things that they do at that point, and I think that would be part of any, I can't imagine it wouldn't be anyway, but would ask that be part of the
And that's, again, why
thing
I'm
that.
so glad to have a commission with staffing
Right.
that has the resources then to focus and devote to that kind of work that was done, again, following the Virginia Tech tragedy. I remember a number of information, but also in our intensity of the last session in trying to get a handle on this. I know Council Steve Mutnick in particular, but also some other interested parties. There are a number of attachments that are of interest about what other states do and what other relevant court decisions have been on appeal in such issues. So all of that is indeed anticipated in what I think is absolutely warranted as a full study, because it's very key to how we progress in the coming together of the law and services in mental health, and the human condition, I will say, for all involved. Are we at the, yes.
Just to clarify, so what I will have for your report is that, we've looked at this situation. We note that currently, the way the bill is drafted, the standard is the existing standard. And instead of making a decision in this group about whether that standard around dangerousness needs to change, the recommendation is to refer the issue to the Behavioral Health Commission for further study. We want them to look at whether the emergency custody order, as the bill is drafted right now, is the appropriate mechanism for linking a person to services if that person is in need of services. But really the broader question is, how do other states handle this issue, the legal question, the evidentiary issue more broadly? What options do they have for a person who introduces that kind of evidence at a trial? If a person is acquitted under this kind of statute, what happens to that person? Are they linked to services in some way? If they're not acquitted but some other outcome occurs, what do those pathways look like? So what are other states doing? I think we can include in there a question of outcome data for those states, if it is available, to understand what's happening to those individuals after they're acquitted, so we'll have more information about that. Also, if the ECO is the appropriate mechanism, do we need to have any changes to the criteria? We can ask them to consider the constitutional issues, procedural issues, and also look at perhaps the impacts on the behavioral health system that using something like an ECO might have. So we can include all of those things in the study recommendation to give them a statement of the things you are particularly concerned about looking at.
If I may add to those notes 2 things, whether or not whether it should be a shall or may, as far as the presiding judge in whatever procedures that we come up with, and also some reference to whether the appropriateness of using any of the approaches currently done with drug courts and other special dockets, so that it's within the body of Virginia law and procedure.
I can do that. Delegate Bell, is there anything else?
Anything else you would add?
Yeah, I don't, so just from a timing perspective, so this would be taken up not in the next 2 weeks, I assume. It would be in the coming, expectation of the coming year.
Yes, I don't think we would be able to solve this before the coming session.
Okay. So I think that's a good idea. I would say that we are, lots of smart people come to this building, especially in January. I've never thought the perfect has to defeat the good. So if something comes up in the meantime that might do something positive for the next year, I would certainly plan to talk with people and bring it as a bill, not to foreclose the bigger thing we're working on, but just I'm worried that we would wait a year and there'd be some bad outcomes in the meantime. So that's all.
If I interpret you correctly, what I would hope, if there are bills that would specifically change what was passed last year, that we at the very least carry them over pending, if not refer them to the commission, the Behavioral Health Commission. It would be certainly my hope that we don't change the statute pending how some of these questions might be encompassed that might lead to legislation. I'm going to give one specific again. I had to reassure myself in talking with the Commonwealth attorneys that in fact we had clarified that the presiding judge could initiate an ECO. And so I think there's a lot of lack of understanding of what was passed last year. And so I'm concerned that legislation not be enacted that changes something that may or may not actually have been enacted last year, if you follow how I'm trying to express it.
I follow. As you know, I didn't support this. I thought it went too far, and I thought it left a dangerous gap. And I'm just one person, and it may be well that what you're describing would happen no matter what we did. But we do amazing things down here sometimes, and I don't want to foreclose the opportunity to do something if there's something. And again, I'm not
determined, is what you're saying.
Yeah, I'm not sitting on something that I'm going to surprise everybody with. But certainly there has been discussion prior to this meeting of, oh my gosh, this could really lead to dangerous outcomes unless it is fixed. Now the fix, again, what some people see as a bug, others see as a feature, and so. Certainly there are conversations, and it sounds like you are also engaged in conversations of concerns people have, and I don't know if they fear that it could happen, it's about to happen, or it has happened, but I think that would drive some thoughts. And it's, again, I like studying things at great length, but I also, sometimes we, again, wait for the perfect, and in the meantime, bad things happen. And so, that's all.
Before we act on what Sarah has outlined, I believe it's appropriate to turn to any public comment before we act on it. Where public comment and then directions to staff. So I take directions to staff are either recommendation by force of our personality, or if we get another vote, an actual vote to recommend what you've outlined. So with that, do we have people signed up for public comment?
Madam Chair, we don't have anyone signed up, but I do believe that there was someone a couple of people who wished to speak. Again, if you could take your place over here at the microphone and introduce yourselves.
Shock me?
Yeah, I would. No promises, and it's really scary.
But we've got a lawyer here who represents
No, I already shocked myself. I'm the problem. Before you got here, I shocked myself.
It probably has qualified immunity, so we wouldn't get very far.
Button under the table for when I drone on too long again.
Good afternoon. I am Anna Mendez, the Executive Director of Partner for Mental Health in Charlottesville. I am at least partially responsible for the convening of this meeting this afternoon, and I am very grateful, Delegate Watts and Delegate Bell, for your time here today. A couple comments that I would like to make. I'm feeling a little lost without my 3-minute timer, so I'm gonna do my best here. For the sake of clarity for anyone who is watching this and having some confusion, I just do want to be incredibly clear that the current ECO criteria time frame is in the near future. And I will send, when we changed our ECO criteria back after the governor's commission after Virginia Tech, it was changed from imminent risk to in the near future, and Professor Bunny and Dr. Monahan and Dr. Cohen at ILPPP have written a really strong document about the interpretation of the current ACO criteria, and I will resend that to everyone on the commission because I think it is incredibly helpful in grounding us in what the current statute actually is. It is troubling to me to hear from you, Delegate Watts, that you're hearing that there's a lack of understanding about this bill. I did offer, in partnership with the Virginia Indigent Defense Commission, Partner for Mental Health and the Commission have provided a very extensive training to Defense Counsel about this, and we did approach the Virginia Association of Commonwealth's Attorneys to provide the same training to them, and our offer was declined. So I will make that offer again, because if you are hearing that our Commonwealth is not adequately informed, that is incredibly troubling to me. Though one thing that I will say, what we are hearing in Albemarle and Charlottesville about the impact of this legislation is that it is being used. We are not aware of any instance in which a person has, anywhere in the Commonwealth, in which a person has been fully acquitted as a result of this new rule of evidence. We are, however, aware of multiple instances in which this new rule of evidence was used to leverage increased participation in established mental health dockets, which we feel is a win for the individual and a win for the community. So we are incredibly grateful for that outcome of this bill. I will say that at Partner for Mental Health, we are aware, since the General Assembly last met, we, apart from this legislation, we are aware of bad outcomes in our community. And what is most heartbreaking about those bad outcomes that had a negative impact both on public safety and on the individual living with mental illness is that in every single one of those cases, the person with mental illness attempted to access community-based care prior to the event, and they were not able to due to lack of capacity in our community-based system. So I would just essentially beg the General Assembly that as you are working on this issue, that you are also considering how significantly underfunded and inaccessible our community-based services currently are. Thank you very much. I appreciate your time.
Thank you very much, and thank you for your work on this during the last General Assembly session.
You're welcome.
Are there other comments?
Madam Chair, I believe that's it.
All right, thank you very much. That then closes public comment period, and I would, since there's no motion, please, counsel.
Can I make a motion? I mean, is that,
Well, but we
the two of
can't
us have
pass
enough?
it,
Okay.
yeah. So, yes, sir. Okay, so I've just been told that it is possible that Delegate Price might be able to join us in 5 minutes or so. So if we can just stand at ease until that time.
Yes, ma'am.
If we can now
I'm sorry.
be back in order. We now have a quorum, so we're able to, so I'm going to recap, because we now have a quorum, and what we have been discussing for the last half hour plus is the enactment clause of Senate Bill 1315 and House Bill 2337, which said that the Deeds Commission should look at the issue of the standard if someone is acquitted by reduced capacity, of what the standard would be for mental health services, of whether it should remain as our current standard is, that there's a substantial likelihood that in the near future there would be harm to self or others, and whether there should be any sort of different standard. That's what the direction was to us. We are in the situation where we're still sitting here as a subcommittee of the Joint Committee on Mental Health. We are going to recommend to the Commission on Behavioral Health that this be a study of the Commission much more broadly undertaken, as far as not just the standard, but what the procedures would be, what the court's role might be as far as may or shall. I actually, now at this point, if I can turn to Sarah Stanton to outline the issues that we are about to craft into a motion to recommend to the Behavioral Health Commission.
Yes, Madam Chair. So the situation is that the way the bill is drafted, it allows a court to issue an ECO for a person who has been found not guilty. And the criteria right now is the existing criteria for an existing ECO. So really, it doesn't change what's available under current law, except that the court might offer enter the order as opposed to a magistrate who does that now. So in looking back over what the issues have been last session and this summer, we realized that we need a broader inquiry into when you have a person who is found not guilty because they were not able to have the intent to commit the crime because of their mental state, and that person needs services to protect themselves or to protect public safety. What is the appropriate way to get there? Is the ECO the appropriate way? Which seems like perhaps it is not. But it could be, and if we need it to be, do we need to look at different criteria? Would the criteria apply to everybody or just in these cases? Or is there a different sort of mechanism for helping a person who's acquitted under that section access the services they need to protect themselves and to protect the community if that's what we need? So we're going to ask the Behavioral Health Commission to do a more detailed study. They will have the appropriate staff who will have the expertise to do the quantitative and qualitative type research we need them to do to answer those questions. Questions generally being, what is the appropriate mechanism for linking a person who has been acquitted under this section who needs services to those services? In looking at each of the options, what are some of the what the benefits might be and what is going to be the best fit for Virginia? We're going to ask them to look at the constitutional issues because there are a number of constitutional issues that come up in these cases. Procedural issues, impacts on the individual's access to services, and the broader impacts on the behavioral health system as a whole. We're going to ask them to look at what other states do, not just in terms of do they use an ECO or not, but do they have some other mechanism in place that accomplishes this goal? If so, how does it work? How is it working? Hopefully they will be able to pull some qualitative data for us about what the outcomes are for these individuals in these cases, so we have real-world knowledge of the situation. We'll also ask them to look at the appropriateness of using something like a drug court or another special docket like a mental health court, basically to cast a broader net, to understand if there have been any legal challenges to cases involving these things so that we can get a more comprehensive and independent analysis of what the options are and how those might fit for the Commonwealth. And to include a broad array of stakeholders, including Commonwealth attorneys, defense attorneys, the Supreme Court, the Office of the Attorney General, but also the mental health advocates, individuals who may have experience in this realm, individuals with lived experience, and those types, so that we hear from all viewpoints in this process.
add on that last point, I would observe this is why the Commission on Behavioral Health is so important, because it can bring together what the Crime Commission would not be looking at as far as stakeholders in the mental health field, and yet we can be looking at those within the justice system and within the treatment system as all being stakeholders at the table. So with that, if there are no further questions, a motion would be in order.
I'm happy to move for that.
Okay. Any further discussion that be drafted into a recommendation to be made to the Behavioral Health Commission? Yes, please.
Madam Chair, does anything else more formal have to happen, like a letter, or like how does this get to the full Deeds Commission, and then how does that then get to the commission?
We have a meeting coming up prior to session that this would be appropriately on the agenda. And we have been asked, again, we were not only asked by the enactment cause, but it was identified that with the full commission coming into being, we now had the opportunity to really look at this right and not just the narrow question of the standard.
And Madam Chair, to also answer that, the technical side of that question, while you could certainly do legislation if somebody really wanted to, a letter is often appropriate in this case. More and more the commissions are using a letter as opposed to a resolution or a Section 1 bill to collect these types of studies. Also, I'd note that while this recommendation is coming out of the Joint Commission, going to the Behavioral Health Commission, it's almost exactly the same membership, so you'll know.
Right. So whatever is currently appropriate, we will so do.
Gotcha.
Got it. There's a way to do it.
We'll do it.
All right, any other questions, discussion? All those in favor, please say aye. Aye. All right. Is there anything else to come before this subcommittee? If not, thank you all for your involvement and concern, and have happy holidays. And we'll see each other before then, probably.
Probably over and over.
Yeah.
You on Monday
Yeah.
with HWI.